These two false allegations must be placed in a proper perspective. Mr. Jackson has interacted with millions of children. Many millions of children around the world love Michael Jackson and never allege that he harmed them in any way.
It is official. The ruling that could make or break the case against Michael Jackson has been handed down. Jurors will hear about prior allegations of abuse by Michael Jackson. Testimony about 5 other incidents, fair game, will come from a handful of witnesses, including a number of former Neverland employees and one of the prior accusers who was paid millions for his silence back in the 1990s. The judge saying earlier today he'd, quote, permit testimony with regard to sexual offenses and alleged pattern of grooming activity by the defendant. Up until now, prosecutors have been taking some heat for the state of their case, but this ruling could turn it all around for them. NBC's Mike Taibbi was in the courtroom today. He's standing by at the courthouse with the latest. So, Mike, who are we going to see on the witness stand, and what are they going to say about these alleged prior acts?
Well, you call it a handful of witnesses. It is exactly that, Dan. 9 in number. You know, this was a big ruling. You could tell because it got really personal and intense in the arguments before Judge Melville. At one point, Tom Mesereau, whom you just heard from, Jackson's lead attorney, saying the prosecution is desperate, that their case is weak, it's bad, and it's getting worse. And Tom Sneddon, the prosecutor, answering back that Mesereau himself was obnoxious, abusive, mean-spirited in his questioning of the accuser in this case. But at the end of the day, Melville, as you said, the judge allowed these 9 witnesses. They are, and we'll give you a list here, that 1990 accuser to whom you referred, his mother, and the mother of the 1993 accuser. That accuser and his family were paid upwards of $15 million. And then people, Charlie Michaels, who's a female security guard from that 93 case, Philip Lamarck, a chef at Neverland in 93, Adrian McManus, who's a maid, and Ralph Chacon, a security guard, the 2 of them involved in a suit against Jackson, which they lost and were ordered to pay damages upwards of $1 million. Bob Jones, who worked for MJJ Productions for a number of years, writing a book, and Charmaine Sternberg, who worked for MJJ Productions and was a gift coordinator, which means presumably that she could testify to some of this grooming activity that you were just mentioning. But here's the thing. I talked to Jim Rogan last week, the former California assemblyman who authored the bill allowing this old evidence in, and he said this could be a case of be careful what you wish for the prosecution, because every one of these witnesses is going to be attacked by Jackson's team. Many of them sold their stories to supermarket tabloids and tabloid television. 2, as I mentioned, were involved in a losing lawsuit against Jackson. Others, Bob Jones writing a book. Others have changed their stories demonstrably, and you know that Tom Mesereau, as he said in court today, is going to conduct full-blown trials, if it comes to that, to try and impeach every one of these stories. But the stories are going to get in. It's cumulative stuff, and you wonder what the effect on the jury is going to be when they hear not 1, not 2, not 3 or 4, but 5 previous incidents and witnesses who are saying it happened then too. Very quickly, Mike, today George Lopez, the comedian on the witness stand, quickly summarize if you can. Strong witness for the prosecution. He said that the mother of the accuser in the instant case never once asked for money, never once asked for any assistance whatsoever, and that's a cornerstone of the defense case, so the mother was in it for the money. So another strong witness for the prosecution. George Lopez saying it was actually the father instead of the mother who seemed to be sort of trying to scam him. Mike Taibbi. Actually, you're going to stick around. All right. My take. I've said it before, even if this boy and his family are of questionable credibility, this could change everything for prosecutors. It is the right legal decision, a devastating blow to Jackson's defense. How devastating, though? Joining me now, criminal defense attorney, NBC News legal analyst Ron Richards, who was in court today, and criminal defense attorney John Burris and Connecticut State Prosecutor Susan Filan. All right, Ron, I told you this was going to be admitted, and you kept telling me it's not going to be.
Well, Dan, I was still waiting for some accuser to actually want to testify in this case, and still we're not getting any. I think the prosecution is going to be in for a...
You're getting the 1990 accuser. Well, that's a big deal. You're making it seem like this isn't a big deal. It's going to be another kid who's going to come into that courtroom, now an adult, and say, yeah, Michael Jackson molested me, and that's why he paid X amount of dollars to me.
Well, let me respond to that. That kid was interviewed by Lauren Weiss, who's a district attorney in Los Angeles, now a Superior Court judge, and she didn't think a crime had been committed, and neither did the Santa Barbara sheriffs when they interviewed him. And nobody filed any charges at that time, and I think that it's going to be very suspect 15 years after the fact coming into court.
John Burris, you agree with Ron? No big deal. Come on.
Well, it's a big deal.
No,
it's a huge deal in the sense that the evidence is coming in, and at least jury will have access to it. But I do think that it's not necessarily the death knell for Michael Jackson in this case, because each one of these witnesses will have their own credibility problems. And when that happens, you may then have the whole question about what is the motive here? What's the interest here? And it very well may be that this could be very helpful in the long run to show how desperate the prosecution case really is as it relates to this other case, because you have to bring in all of these others to try to make this case through these other witnesses. It's not good. You'd rather not have it, but it's not the end. He does have an opportunity to really blast these individual witnesses as to their own individual motives.
Yeah, but Susan, the problem is that each individual is going to have a different motive. And look, I'm not saying that it's necessarily going to lead to conviction, but this is the biggest thing that's come out of the Michael Jackson case for the prosecution, in my mind, even bigger than the accuser testifying, because he had problems. And I think that this is the one thing that could lead these jurors, in conjunction with everything else, to convict.
Dan, it's huge. It's huge. I mean, on the one hand, they hear the accuser testify about what happened to him. They've heard him cross. They've heard him be impeached partially. But now they're going to hear a parade of other people saying, it happened to me, it happened to me, it happened to me. And it's pretty much identical. It is the same pattern of grooming. It's going to be very, very hard for a jury to just disregard everybody's lying, absolutely everybody. Everybody in this case and everybody in every other case. I think it's not game over for Michael Jackson, but it's a huge win for the prosecution.
Yeah.
And the prosecution can't speak, but one of the things that the Peterson prosecutors got to say finally when it was all over and the gag order was removed was, if they could have said 2 words all along, they would have said, trust us.
Yeah, well, you know what? Don't give them the credit that they want to get now. The bottom line is they were trying that case horribly at the beginning of this case. Let's not revise history just because they won the case, because they had a lot of strong evidence that they were somehow, the Clarence Darrows of our day. I mean, the bottom line is those guys, look, I like the guys. They did a good job at the end of the case, but at the beginning of that case, it was a disaster. All right.
Dan, I don't agree that this testimony should have come in. A lot of this testimony is well over 10 years old. It is sort of a rule of thumb that evidence over 10 years old on pattern and practice, common plan and scheme doesn't come in. So this is very surprising.
Mike Taibbi, you want to get in?
Yeah, not under California law. That's absolutely not the case. In fact, I think Tom Sneddon made a very tight argument based on case law saying that there is not a situation where this evidence was allowed in and a court of appeals overturned it, that the legislature and the judiciary up to the California Supreme Court affirmed the admissibility of this evidence.
Yeah.
So on that basis, it's in.
I go to the question of timing. I think it's remote. It's very remote in time.
But the laws in California doesn't talk about remoteness. It talks about similarity.
It actually does talk about remoteness. But
it's not in the code.
Ron Richards, go ahead.
But just real quick, there's never been a case, Susan, and you know this, in history of California jurisprudence where you've had 5 people accusing someone else of molestation, but those 5 don't show up. And what is Tom Sneddon going to say when that child actor, and we all know who it is, gets on the stand and says, those witnesses of yours were lying? That's going to be a problem.
Yeah, all right. Well, we shall see. Look, again, we're talking about some people who are going to say that they witnessed abuse. There are going to be others, one kid now an adult who's going to come in. I got to tell you, I think some of the witnesses could be even more powerful because they didn't get the money.